Why would Congress delegate to the president a power to federalize the National Guard but not use them? How does that make any sense? Obviously, these are completely feckless arguments being made by these progressive fascist feckless judges. It's unbelievable. When this gets to adults, they have to say either it's both or it's neither. Either the president lacks the authority to federalize because the conditions of 12406 have not been met. There is no colorable basis to believe they've been satisfied, in which case the president simply can't use the National Guard, the state militias, under 12406, or they have been met and he's allowed to use them. You can't say he can activate them but not use them. The second court win for Trump, the Ninth Circuit Chief Judge, acting solo, grants an administrative stay of the decision, the order of another female judge, another unelected, black-robed, tyrannical, inferior district trial court judge, Karen, I'm not kidding, that's her first name with an I. Even worse, right? Karen, with an I, Immelgut, had ruled that Trump lacked the authority to federalize the National Guard, the Oregon National Guard, under Statute 12406. And for those who may not remember, 12406, whenever the United States or the Commonwealth is invaded by a foreign nation, that's not happening, of course, or there's a rebellion or danger of rebellion, or the president's unable with the regular forces to execute the laws of the United States, the president may call into federal service the National Guard in such numbers as he considers necessary to suppress the rebellion or execute the laws. And Judge Immelgut, Karen Immelgut, had said, no, Trump, there is no rebellion or danger of rebellion. In my opinion, I'm overriding the judgment of the President of the United States, our commander-in-chief, and I'm overriding his judgment that he is, without the regular forces, able to execute the laws. Remember, she said execute the laws means if the president tries 1,000,000 times to execute the laws and he can do it even once, then he's not unable to execute the laws. That was the standard she applied. A standard she applied when her bosses on the Ninth Circuit Court of Appeals had already said, when the president's making these National Guard decisions, we have to give him tremendous deference. If there's a colorable claim, if there's any evidence to support this conclusion by the president, we have to respect that decision. We're not co-equals with the president. The only way we could override his decision would be if it was insane. There was zero evidence to support a judgment that was a danger of rebellion or that he was unable to enforce the laws. Even by that standard, Karen Immelgut said, no, I don't like the National Guard deployed, so I'm just going to override the president, effectively making her the commander-in-chief, the president of the United States, for purposes of federalizing and deploying the National Guard. Now, she had been kind of wishy-washy about all this. First, she said, well, he can federalize them, but he can't deploy them. And then later she issued a preliminary injunction, said, no, you can't do either, Trump. You can't federalize or deploy. So what we have here now is a decision out of the Ninth Circuit Court of Appeals, the chief judge of the circuit acting solo. So it's not a 3-judge panel. I wonder if he's doing this to provide political cover for his colleagues. Grants an administrative stay of that order saying that Trump cannot federalize the National Guards. So Oregon, and of course, this is all about Trump activating the National Guard to deploy them in Oregon, in Portland, the ICE facility in Portland that's been besieged by violent mobs for months. Then when this judge, Karen Immelgut, said, no, I'm not allowing you to activate the Oregon National Guard, he said, all right, I'll just use the California and Texas National Guard instead. And she said, oh, no, that's not what I meant. What I meant was no National Guard. You can't use any National Guard. So now we have the chief judge. I don't know how to pronounce this name. Murgai, I'll say. The court has received the government, the Article 2 executive branch's emergency motion for a stay pending appeal on this case. This is the injunction from Judge Karen Immelgut telling Trump that he doesn't have authority over the National Guard under that statute 12406. The request for a partial administrative stay is granted. The order of the unelected black-robed tyrannical inferior district trial court judge Carol Immelgut from November 7th, that was 2 weeks ago. The permanent injunction that she issued, permanent injunction, meaning it was going to last for the duration of the litigation, which could be years in federal court. The permanent injunction is stayed to the extent that it enjoins the federalization of the Oregon National Guard pending further order of the court. So Judge Immelgut can't tell Trump he can't federalize, activate the National Guard. Now, it's worth remembering that Karen Immelgut had distinguished between federalization and deployment. Initially, she had said, well, Trump can federalize them, but he can't deploy them. And now this court is saying, well, no, we're going to reverse the part that says can't federalize. But let me ask you a question. Does it make any sense? Does it really make any sense to separate those two? Can you meaningfully separate federalization and deployment? Is there a rational world in which you can tell the president of the United States you have the authority to federalize the National Guard, but you can't use them? What would be the point for Congress to delegate militia authority like that? Because the militia authority under the Constitution is in Congress. To call up the militia is in Congress, not in the president. It's not an Article 2 power. It's an Article 1 power. But then in statutes like 12406, we just looked at, Congress delegates to the president that power, subject to conditions like danger of rebellion, like unable to enforce the law with the regular forces. Why would Congress delegate to the president a power to federalize the National Guard but not use them? How does that make any sense? Obviously, these are completely feckless arguments being made by these progressive fascist feckless judges. It's unbelievable. When this gets to adults, they have to say either it's both or it's neither. Either the president lacks the authority to federalize because the conditions of 12406 have not been met. There is no colorable basis to believe they've been satisfied, in which case the president simply can't use the National Guard, the state militias, under 12406, or they have been met and he's allowed to use them. You can't say he can activate them but not use them. That's crazy. The court's administrative stay is only intended to preserve the status quo. Of course, that's what they always say. By the way, the status quo was activated and was going to be deployed. That was the status quo. The government is directed to file weekly status reports regarding the current status of any federalized Oregon National Guard, including updates on the federalization of any troops. Why would the federal courts have anything to say about this? Briefing on the government's emergency motion for stay pending appeal is stayed pending the U.S. Supreme Court's ruling on the government's application for stay in Trump v. Illinois. So this is an Oregon case, but of course there's a National Guard case happening in Chicago too. Same issues, 12406. Who gets to make the decision on whether there's a danger of rebellion and whether the president's unable with regular forces to carry out the law? The Supreme Court's already considering that question in Trump v. Illinois, and in fact has asked for extra briefing specifically on, for example, what are the regular forces? Are the regular forces like the normal ICE officers you would use to enforce immigration law? Or does regular forces mean the full-time professional Army, Navy, Air Force, Marines, Coast Guard, and Space Force? I don't forget you guys, Coasties, Spaceys. I remember you, which is kind of a crazy take, right? Because that take would mean that President Trump's not allowed to call up the part-time weekend warrior, no offense, guys, but part-time weekend warrior, National Guard. He can't call them up to address a danger of rebellion unless the full-time professional Army, Navy, Air Force, Marines, Coast Guard, and Space Force were all unable to solve the problem. That's the argument that's being made. Obviously madness. Once the Supreme Court rules in that case, Trump v. Illinois, that National Guard case out of Chicago, then this court will set an expedited briefing schedule to allow for emergency motions on the use of the National Guard in Oregon. This case by the Supreme Court, whatever they decide here, should address whatever questions there are in Oregon for all practical purposes. I would hope that would be the case.